Hello, everybody, and welcome to today's webinar, Post-Lockdown Data Protection Challenges Facing Law Firms. So the first thing I would like to ask before I introduce Neil is, can you all indicate in the chat box whether or not you can hear me okay? So just a simple yes in the chat box would be fantastic. If any of you are having problems hearing me, sometimes it helps to switch the browser. So if you're using Google Chrome, possibly go to Firefox or Safari. The other thing I would like to say is that this webinar is being recorded. The only part of the webinar is being recorded is the actual screen that you're seeing. So if you do ask any questions throughout the webinar, at the end, we will not disclose your name. We will simply respond to the question. So if for any reason you need to drop out because you get a phone call, you will get a copy of the recording. Okay, so thank you all for giving us 45 minutes of your time today. I am going to move on to the next slide, where I'm going to welcome Neil Partridge from PDA Legal and ask Neil to introduce himself to the audience.
Hi, Kelly. Hi, everyone. Good morning, Kelly. Thank you very much for having me here. I know that some of our participants this morning have met me or know who I am and what I do. And I think the introductory video set out a little bit about me, but in a nutshell, I'm the operations director at PDA Legal. I'm also a Lexcel assessor of, well, let's just say more than a decade. And I've also written and authored webinars and documents and presented at conferences for Law Society on things like Lexcel risk, data protection, cybersecurity. As well as I was also the person who trained, I know this isn't just about Lexcel at all, but also I trained all the Lexcel assessors and continue to do so on things like data protection and risk. So that's a little bit about me. I'll say no more for the minute, but thank you, Kelly.
No worries. And my name is Kellie Peters. I'm co-founder of Databasix, and we have been working alongside Neil for a couple of years now, though Neil is vastly more experienced with law firms. So without further ado, let's really kick on in terms of the meat of what we want to cover today. So we have 5 discussion points that we are going to cover. Each in their own right would take longer than half an hour. So these are very high level discussions. If you'd like a follow up with us afterwards, please let us know. What we want to talk about is that the regulation has now been in force for 2 years. And what we have found is that a number of law firms haven't sufficiently mapped their data and are now finding problems. And we're going to talk about that in a little bit. We, in the current climate, we are seeing mergers, acquisitions, and sadly, some liquidations. So we'll be talking about the data protection risks that you need to consider. We will be talking about, with the current economic downturn, the decisions about redundancies and the impact that staff may feel about that decision and their right to ask for access to their data. We will then be talking about the everyday managing risks of staff continuing to work flexibly, and they may even be asking to continue to work flexibly post-lockdown. And to end on a real positive, how the regulation can support you in terms of contacting past customers to enable you to thrive and survive the COVID lockdown pandemic. So I will first want to cover just a few rules about GDPR, and this will then shape the rest of the conversation. So the data protection regulation, the general data protection regulation, is a very complex piece of European law. It was brought into the UK domestic law as the Data Protection Act of 2018. And there are essentially 8 things that we always need to be mindful of. We need to be fair, honest, and transparent with everybody, staff, clients, suppliers. We need to be clear about our purposes. We should only be processing information about data that allows us to make decisions. It must be kept up to date. We should only keep it for a certain period of time. It's paramount that we keep that data secure, and there are many challenges with the lockdown that we are faced. We have to respect individual rights, and we are going to touch on that in terms of one of our questions. And we absolutely, as organizations, demonstrate our accountability. So that's the new principle that's come in under the regulation. It was talked about in the previous law, but it is now enshrined in law, so we have to be accountable. So take a breath. Let's talk about, is your register of processing activities accurate or up to date? Now, you may know this as your information asset register. You may know this as your data mapping tools that you have used. But essentially, the regulation requires you to have a register of processing activities. What we have found is that whilst the regulation requires you to document what personal data, so it's not just employee data, it's the types of employee information, for example, you're capturing, where it's stored, why it's stored there, what security measures you have in place, what's the lawful basis for processing that? Is it legal requirement? Is it a contractual obligation? Is it consent? And this is a no small task. I've spent hours mapping organizations' data. And it was a massive task for many of you, I imagine, in the build up to May 2018. However, since the lockdown, questions that I've been asked have been checking whether or not they need to update this register. So this is a live document that every time you make a new decision to collect new data, and you may have done so during lockdown for health status of your employees, you must be updating your register activities. Now, I want to ask Neil to join in now, because there are things I wanted to ask Neil in particular, that what he's seen from his experience with law firms about mapping the data, in particular, the link between data protection and the SRA. So Neil, what's your view of mapping data from a law firm perspective?
Well, thank you very much, Kelly. I must confess, I think I hope my internet signal is still clear. It just fluttered on me a little bit. You'll let me know if that's not the case.
Oh, yeah.
We've got, I think at this stage, let's just cover the scary stuff, because I want to be positive today. But I would draw attention to a number of SRA requirements straight off the bat that, in conversation with some legal organisations, have perhaps been overlooked or not considered. 2.1 of the Code of Conduct 2019 for legal practices, legal firms. 2.1a simply says you will comply with the SRA's requirements, as well as with other regulatory and legislative requirements which apply to you, which of course includes the Data Protection Act 2018 and the GDPR. Also 2.2, and we talk about accountability and maintaining evidence of accountability, as you rightly pointed out, Kelly. 2.2 of the SRA code says you keep and maintain records to demonstrate compliance with your obligations under the SRA's requirements. Refer back to 2.1a. 2.3, you remain accountable. Again, 2.5, you identify, monitor, and manage risk. And part of this, obviously, identifying what you've got to be able to manage that risk, but I'll come back to that briefly in a minute. And also, SRA Code of Conduct for solicitors, RELs, and RFLs, you maintain competence to carry out your role and keep your professional knowledge and skills up to date. These things can't be overlooked. And of course, we are going through economic times and challenges as entire countries that we've never known or seen known in recent decades. But regulation doesn't stop there. So that's, if you like, that's the scary stuff. That's the background. What are we actually finding? Well, my own experience, and I've personally I've conducted more than 500 visits to legal practices. The teams I work with, it's more than 2,000 visits. And I haven't got the exact stats, but I'm prepared to make a pretty good bet on them, their accuracy. About 99.9% of legal practices I visit haven't entirely mapped their data in the first instance, or considered the data that they actually have and how they're looking after it. In GDPR terms, we call this the Article 30 record. If we're talking about Lexel, it's 3.1b. And this is where you'll have appropriate records, and appropriate means compliance with Article 30. Quite often it's things that haven't been realised, or possibly they haven't been documented effectively because they weren't investigated properly in the first place. The golden rule is, if your Article 30 record, that sets out what you've got, how you're looking after it, or what basis you're processing it, and who gets to see it. If that record isn't accurate and correct, it is impossible to have a meaningful policy or conduct meaningful training for staff for everything else to do with data protection. So it really is the backbone, in my opinion. But also, it's one of the key documents that gives you a bit of fight back. If ever there was a problem with a regulator, you could say, we've accurately mapped this. But there's also things I think we're going to come to later on where having a good Article 30 record is genuinely helpful in dealing with problems. I would say the other thing to take into account here when we talk about the fact that we've got to keep our records up to date is every law firm I've spoken to and I've commiserated with, they've had 4 years, forget coronavirus for a minute, they've had 4 years of regulatory turmoil. The Data Protection Act came in, AML regulations changed. If you're a Lexel firm, Lexel rules changed. And most, not to say most critically, there's other critical things here, but the SRA rules changed last year. And every time that changes, you have to reflect upon your procedures, the backbone of evidence of all training and all operations in the practice. So I do sympathise with firms, but it's about making sure that your procedures and policies are not redundant. And I would say we're going to cover that today, I know, but I would say start with your Article 30 record. Make sure that's up to date. It's worth reviewing. And of course, if you've merged or acquired or made redundant or brought people on board or changed some of the work that your practice does, and some practices have done that, you're merging or acquiring, there will be new touch points on data protection that definitely need to be considered. And just to go back to your data map, your Article 30 record is a really good place to start because everything else falls out from that.
Perfect. So I think for me, the takeaway for everyone listening to this is that was incredibly insightful. I would say to everybody, the question down the bottom is, how do you demonstrate your compliance with Article 5? And that is your lawfulness, your transparency, and retention and all of that, which is all covered in your register of process and activities. So if you haven't done it, I would urge you to map your data. If you have mapped your data, I would encourage you to look at it and build in a regular routine where it doesn't have to be weekly, but maybe quarterly or 6 monthly, you're checking that the register is still accurate. And more importantly, if you make a new system change, like Neil alluded to, you go back to your register of processing activities. So what I then wanted to talk to, and Neil just mentioned it, was this mergers and acquisitions. And I know in the build up to us writing this webinar, Neil and I was talking about what we felt were the major challenges, and we both suggested that it would be useful to talk about mergers and acquisition because there will be requirements on you as a law firm about the data that you're going to transfer if you are acquiring a firm, or if in fact you are being acquired or merged, or even if in fact you are, or firms that are in the unfortunate position of being liquidated. So what I just wanted to touch on is some of the things that I feel that it is important for you to consider. So the market is in turmoil. However, there are risks and there are financial penalties if you don't adhere to the risks. And I wanted to raise the point about Marriott. Marriott have had an enforcement notice with the intent to fine. It hasn't happened yet, but the intent to fine them a significant amount of money. And that fine was in relation to a company that they acquired, and that company having had a breach of personal data, and it wasn't disclosed in the sale. Therefore, Marriott took on the essentially took ownership of that and are now facing quite an incredible fine. So my points here are, for both the buyer and the seller, you have to assess what data is going to be transferred as part of the merger and acquisition. And you really do want to do your due diligence. You'll do it anyway from a financial perspective and your employees, but really don't forget the data. Make sure that you ask questions such as, is the seller demonstrating their compliance with the regulation? And I had a conversation with a data protection lawyer late last year, and his view was, if he was providing guidance to a firm that was buying another organization and there was lax data protection policies and procedures, he said that would impact the buying price. So as a seller, if you're intending to sell, make sure you have the policies and procedures in place. If you're buying, make sure you ask those questions. And some of those questions will be, can the seller demonstrate their data, that they have the ability to evidence any breaches that they have had, or any disputes that they are currently having about data breaches or breaches? Can the seller demonstrate an adequate IT and cybersecurity mechanisms? Has the seller been properly and regularly audited? So it's been 2 years since the regulation came in. Neil's talked about regular changes to regulations for law firms. Can you demonstrate that you've been audited? If you don't have a data protection officer, but you have a data protection lead, can you demonstrate who is accountable and is leading data protection in your firm? And can you evidence compliance with data protection law? Now, obviously, that doesn't cover the transfer of data, but I wanted to ask Neil to chip in at this point to say, in a mergers and acquisition position from a law firm, there will be matter files that will go from the seller to the buyer. And what are the things you would say need to be considered, Neil?
It's a huge area. It's, I suppose, if you're an acquiring organisation, it's a positive thing. If you're not an acquiring organisation, it's a very challenging and difficult time. There are. I'd open this by saying, really, and this is something I've said flippantly, but actually quite realistically for a long time now, the chances of any two firms in the UK managing their personal data in exactly the same way are in the billions to one. It doesn't exist. If you think about the cocktail of the way you manage personal data, so you think about it's down to what do your staff know, how have your staff responded to, what do they know, how have they been trained, what case management system are you using. The fact you could be using an identical set of systems to another practice, but if you've got one computer that's got different software to everybody else, your cocktail changes. So the permutations, as I say, are in the billions. So it's important, I think, to start out from that point there, that no two firms manage data in the same way. So now you're looking at a merger or an acquisition. Let's start with the basics. Let's move away from computers for a minute. Let's talk about paper files that are sat in a storage unit somewhere, because they will be there if the firm you're acquiring or merging with has got them. So at some point, you're going to have to engage with the organization, possibly the outsourced service provider that is actually storing those papers, and you've got to work out how you're then going to bring them across into your organization. But let's just move back. That's just one example. Let's move back to electronics for a moment. What are the chances that the organization that you're acquiring or merging with uses the same case management system as you? There's a reasonable chance, but probably less than 1 in 20, I would say. There's quite a few case management systems out there. There's also, of course, accounts systems. There's also systems that monitor compliance. There are all these different systems, and they all contain personal data. And I think it's important, as you say, Kelly, as well, we talk about HR and staff, not to get too caught up in just thinking about client data. But if I focus on client case management systems, just because it's a useful point of reference, that's the transfer potentially from one case management system to the other via the internet or electronic means anyway, of a stack of personal data. So what kind of controls, going back to where we talk about compliance with 2.2 of the SRA Code of Conduct and 2.3 remaining accountable and keeping records in that order, how are you then going to be able to evidence how you've done this? So what due diligence will you have done? Have you looked at this and thought, actually, do we need to do a data protection impact assessment? Do we need to go as far as that? But have we actually identified what the risks are? What assurances, because we could be for a short time dealing with not one, but two case management system suppliers. So what assurances have we got from them, bearing in mind that under Article 28 of the GDPR, the word reasonable doesn't appear anywhere actually in Article 28. It says you will have appropriate controls in place, and that includes a contract. So it's making sure that your satisfied contracts are in the right place. It's also about saying, okay, let's look at the training we need to do with staff. We will no doubt probably keep some of the staff that we are acquiring from the other firm, but there may well be a need to examine what training have they had, what training have our staff had. While we're going through the transfer of case management system, how are different staff going to relate to this? What do we need to do? Because we could be responsible for those staff too. So I'd say in terms of checkpoints, I would be looking at this very carefully. I would be saying, okay, I'd like to know what the acquired or merged firm's information assets, I'll start again, what their register of personal data looks like. How does it sit next to ours? What are their arrangements with their case management system provider? What contracts do we need to have in place? Maybe we need to look at two sets of contracts there. What training do we need to provide staff? How are we geared up to be able to do this? So it's about reviewing what we've got, reviewing where we want to go, and making sure that we've evidenced where we want to go there. And I think staff and systems combined need to be looked at to get the full picture.
Perfect. Thank you very much. Okay, so on to the next meaty subject of subject access requests. Now, only yesterday when I was looking at the news, there were 9,000 jobs reported to have been lost in a 24-hour period because the furlough scheme had come to an end. We're now moving into the second part of the furlough scheme where people are coming back at a part-time basis. And between now and October, it is expected that there will be a significant number of redundancies. Now, with that will come some very unhappy staff members. They may feel that they have been unfairly treated during the lockdown period, and they may wish to exercise their right for access to their information. If you're an employment lawyer, it's typically one of the tools that is used when asking for this information. But they are no small task to complete. And what I have found from experience is that people typically wait till the last minute to respond to a subject access request, and that's where all the panic comes in. If we're talking about staff supporting or submitting, should I say, a subject access request, you will know who they are. So you are very unlikely to have to do any sense of verification of their identification. So you've got 30 days or less than 30 days from the point that you get that request to come in. And I know that if that member of staff's been with a firm for, say, 10 years and they've said they want everything, they've not narrowed it down, which is sometimes helpful, that could be a task that will take you a significant amount of time. So for me, the questions I want you to consider is, do you have a subject access request process? Can your staff identify a subject access request when it comes in? Because it may not come to the person responsible for HR, it could come to their line manager. And do you have a process in place that allows you to log the subject access request and what your response to that will be? And what I wanted to ask Neil is, with your experience of providing support to subject access requests to law firms, do you have any kind of indication of the amount of hours typically that is invested in responding to one subject access request?
Certainly can, Kelly. In actual fact, I think numbers can be quite helpful here, and there are some rather troubling statistics. There was a survey done just last year to augment your point there. There's a survey done last year in the city in London, not just with law firms, but 56% of all subject access requests came from internal sources. So it's very easy to concentrate on clients as data subjects, but we need to consider staff as well. Here's some interesting numbers. We've supported firms, something that we do. We support firms with subject access requests. And you've asked, Kelly, what's the implication of dealing with a subject access request? It's phenomenal. We've helped firms deal with ones from clients or ex-clients. We've also helped firms deal with internal ones, including one where a partner, he was being let go, and the amount of work that was involved in servicing that. In plain numbers, and hopefully if we get a chance, Kelly, I'll just come back to a couple more details on this, but in plain numbers, it generally needs somebody of senior level to go through a subject access request. At the end of the day, the data protection lead in the organization, whether it's a DPO or a data protection manager, whatever you want to call them, is going to need to take responsibility for this. As I understand it, the ICO and the SRA are almost more likely to jump up and down if these are badly serviced in the legal sector than a simple email going to the wrong place. Mm-hmm. So at £300 an hour, which is probably pretty average for what a very senior person would earn, in our experience, it takes 48 hours to resolve a subject access request. Yeah. Now, if you think 48 hours, that's a whole week. You've only got 30 days to start with. That's once you realize you've got a subject access request. But at 48 hours, and people might say, my goodness, why does it take so long? Well, to give you an example, if it was a client, for instance, it's no good just saying, here's your matter file, off you go. It's not that simple. A subject access request is not about any other data subject. So if you're talking about a trust or where other people's names might be mentioned, even family names of the client who's made the subject access request. And I think it's important at this point to divorce the term client with data subject, because we're talking about the data subject here. They hit you with a subject access request. even though if it was a trust matter, the data subject who's made the request may actually know the other trustees, the other people who benefit from the trust, but he's got no right, or she's got no right, to see their personal data in a subject access request. So it's not just about throwing the whole matter file up and so there you go. You need to explain why you've got the data, what you're doing with it, how you're safeguarding it. There may be some data which is privileged to which they're not entitled. Well, they may need to be told they're privileged information. But if there is other people mentioned, other data subjects on that matter file mentioned, because under Article 15 they are entitled to copies or excerpts of that data, then you would have to redact some of that personal data before you handed the copies or excerpts over. And that's where the 48 hours comes from. And that's just an average. But I reckon, just to close off on that statistic aspect, Kelly, it's somewhere between dealing with a subject access request from a member of staff, particularly if it's a partner, and I have seen a couple of those, they are happening already, or a complex matter for a client. You're looking at between £12,000 and £15,000 worth of lost fee-earning time. It's huge.
Yeah, and I think it is a very complex subject, and we won't have enough time to go through it in significant detail. But what I want you to take away from this webinar is to make sure that you can identify when a subject access request comes through from that member of staff. And Neil is right to mention clients. But I feel that there will be a significant increase in internal subject access requests. Make sure you can identify them and make sure that you can log them so you know what you've responded to, and that you've got people to support you with. I will flick on to the next slide because I'm conscious of time, and this again involves staff. The next slide that I wanted to briefly touch on, which is, even though we're easing out of lockdown and people are coming back to the office, it is highly likely that there will be a flexible working programme for at least the next 12 months, so that we can manage the social distancing that we're being asked to manage. And in fact, some staff may actually start asking that they prefer to work from home. So there are risks, and there have been breaches whilst we have been in lockdown. So for me, I just wanted to be mindful that you're now having to manage an even more complex situation where you have people in the office as well as a significant workforce at home. So think about the personal devices that you're using. I saw a statistic yesterday that said 300 terabytes of data has been downloaded from organisations onto individual USB sticks so staff can work from home. Now, that's outside of your control. Those USB sticks can be lost. What are the measures that you're putting in place to reassure your staff about how they handle that data whilst they're working from home? And as Neil mentioned earlier, it's not just electronics, it's also paper. So when they come back to the office, how are you managing the transfer of those paper files back from their home to the work? And what instructions are you giving staff about how to manage the control of printouts and paperwork? And there is a significant increase in cloud systems that have been introduced over the past 15 weeks. So, Neil, is there anything briefly you wanted to touch on from a staff perspective whilst working at home?
There's a lot actually on this one, but I think this is where we can add some fantastic tips and hints. I think on this one, we know that we are expecting a lot of problems coming from a data protection and cybersecurity perspective in the coming months. When we find out that, as you say, Kelly, a huge amount of data has been transferred, terabytes of data been transferred around, there are going to be an increase in subject access requests, and of course, how are staff dealing with those if they're working from home? Because of course, a lot of subject access requests will come in the form of, what do you know about me, over the telephone, not just pursuant to my rights under Article 15 of the GDPR, I hereby issue with the subject access request. So staff being aware of what they look like is very important, but the breaches will also come with emails being sent to the wrong place. So just a few top tips I'm very pleased to hand out here, bearing in mind that insurers are waiting for the fallout and they're examining this very closely, as well as the SRA. So a few things you can do. Make sure your software register is up to date. And it's very important to understand that it's the software register you need to have up to date. And bear in mind, under 2.2 of the SRA code for legal practices, you need to maintain records that demonstrate compliance. And a good software register is a very good way of doing that. So it needs to take into account not just the software that is owned by the practice, but the software that is being used to conduct the work of the practice. And yes, that does include the software on staff's own iPhones. If they're sending and receiving emails, or even just phoning clients or receiving calls from clients, those telephone numbers, which are personal data, are now on a device. And of course, if you allow your software to become out of date on an iPhone, and I've seen some iPhones used by partners that had there were 4 or 5 updates behind, I have actually said they may as well unlock the phone and go and leave it on a bus and walk away, because that's how secure it is. I think other things to bear in mind is just have a look at what software are being used by staff on their own devices. Windows 7 should never ever be used. Even if it's okay, we've got a VPN and they log on and they go through a cloud system and it's okay, it's safe. It's not, because originally they're still logging on a Windows 7 platform. So if you know what software everyone's got and if it's up to date, that's a really good record to keep. A couple of other things where staff are concerned: make sure you tell them that they know how to use what they're expected to use, that they understand who they need to report concerns to. It's dead easy stuff. Train them to make sure that the Siri and Alexa and other things are not in the same room as they are. Make sure that if they've got a paper file or something that they're taking home in the evening, perhaps have a procedure or home working policy that says you will sign the paper out, you will sign it back in again, or even as one firm does, you will use this lockable case to take it home. And whatever you're doing, don't forget to keep your Article 30 record completely up to date. So part of your data processing controls and your Article 30 record is knowing what systems you're using. So to be able to do that, you have to know what software you're using. So in a nutshell, get your software register up to date. Make sure that your controls are then informed into your Article 30 data processing register, making sure that's up to date. Then you can ensure that your home working policy is up to date, and just stay in touch with staff and make sure they're up to speed. And the final thing I would add to that, several firms are now doing it. I think it's a great idea, and it helps to support compliance article with Regulation 2.2 of the SRA code. Push out the home working policy to staff who are home working, and the data protection policy, whatever you call it, and get each staff member to read and sign it to say they've read and understood it, and you keep a copy of that. Update that every year, and you've got a little piece of evidence there that indicates you've tried to do what you can to avoid a problem.
Fabulous. So we are almost through with the slides, so and then we'll have some time for questions from our attendees. But I wanted to finish on a bit of a positive note, because what we've given you can feel quite overwhelming. Now, what we have seen, and you may have seen this during lockdown, that in the first couple of weeks there was a flurry of emails that came out about updates from services. So, and some people started thinking, well, I haven't heard from you in years. Why am I suddenly now receiving this message? So what I want you to consider is, where you are thinking about trying to generate new business, there's nothing preventing you from contacting your old clients, as long as they would expect that. So if you're outside of your retention period, so you haven't spoken to them in 10 years, it's unlikely that they are expecting to hear from you, unless that the matter that you're working on is as a cycle of more than 10 years. And so make sure your database gives you an indication of how long you should be holding that from a retention perspective. And most importantly, make sure that you have the appropriate lawful basis for contacting them. So you'll be reliant on either consent, because they've agreed to be contacted whilst they're no longer a client, or there is a genuine legitimate interest between you and your past client. And again, you want to make sure that you have done a legitimate interest assessment so you can demonstrate your decision making. So there's nothing that prevents you from contacting old clients in terms of generating new work, because the reality is it's easier to find work from previous clients than to try and win work from totally new people that don't know you, don't know your firm. So please stop and think about the lawful basis, and think about, when you're looking at your data from your systems, would they expect to hear from you? And if it's been too long, then you may need to just remove their information from the database. So I don't know, Neil, if there's anything you wanted to add to this particular slide.
I would, just as a sort of a positive note there, Kelly, if I can. And I think I've been asked about this a lot myself. Can we market to clients? Now, in actual fact, talking to some legal practices, they have actually found that they've acquired new clients because they've very publicly, very visibly said, we're still open for business. And some firms who have been closed or narrowed their services have actually lost clients because the clients weren't able to go back to their normal provider and gone on to a new one. I think the option as well, and just briefly touching on the previous slide and this one, by reviewing what you're doing, how you're managing it. I know that some firms have actually achieved cost savings by saying, okay, why are we using this particular platform or software? Who are we reaching out to and why? By looking at that, analysing how you're doing it and managing it, some firms have said, actually, we don't need this software or we don't need this process. They've narrowed it down and actually saved some money, therefore improve the bottom line. But I think going back to this point specifically, I would just in 30 seconds describe how a firm may quite legitimately go about doing this. And you're quite right, Kelly, you identify your retention periods and you conduct a legitimate interest assessment. I would document that legitimate interest assessment because that is your evidence that you show to a regulator. But if you think very briefly about the life cycle of a conveyancing matter, somebody comes in, makes an inquiry, and you may give them an estimate and you're processing their data on the basis of preparation for a contract, Article 6C of the GDPR, 6.1c, and then they become a client. And so you've got a regulatory obligation or a legal obligation, Article 6 Part C, that is C, sorry, which is a regulatory obligation, but you're also progressing the matter on the basis of progression of a contract. Then the matter eventually closes. Now, the conveyancing matter itself is no more, it is finished, and you have a regulatory obligation to retain that file or parts of that file just in case, not least money laundering. You're going to keep that for 5 years, probably, at least, your CDD. But you maybe have very little reason to keep things much longer than that, a few years maybe. However, it would be not unreasonable, I don't think, and I think you're quite right in this, Kelly, if you've got a private client team, within maybe 2 or 3 weeks, maybe a couple of months, of that particular client having finished their conveyancing matter with you, their matter has now gone into storage. But you could argue it's a legitimate interest for you as their firm to go back to them and say, you've got this new property. Would you like a will, or would you like an LPA, or would you like to set up a trust? As long as you recognise, of course, that because you're saying you're going to do this on the basis of legitimate interest, it's nothing to do with the conveyancing matter, not really, that if the client turns around and says to you, no, I don't want you to contact me from your private client team anymore, you would have to back away. You'd have to back down at that point from that perspective. But I think it's helpful, again, to look at the life cycle of a typical matter and the different reasons for processing to help you identify where you may be able to conduct a legitimate interest assessment about going back to previous clients to offer more services. And indeed, there are some firms that have dropped their conveyancing department.
Oh, you've broken up just a little bit there now. So could you just recap the last point?
Other we do is an opportunity, and there's an opportunity for both. There's no question about it.
So you broke up a little bit there, Neil. So maybe if you can just briefly recap the very last point.
Yes, I would. Sorry, Kelly. What I would say was that if you understand the life cycle of the matter, if you understand the different reasons for processing different kinds of matters, if you are taking on the back of that, we would like to get in touch with potential clients who perhaps we've dealt with before, and you have done a legitimate interest assessment and properly documented it, then actually I think there's a really good opportunity there for firms to say, actually, we do have a legitimate interest, we can contact these clients, and to actually grow the business in a new direction, perhaps to reinforce an existing department that you want to reinvigorate again, or perhaps to move into a new area of law which is directly relevant to your client based on what you've done before. So just know why you're contacting them, document it, do your legitimate interest assessment. But I think there is, again, I've said this before, I think the situation with the lockdown, yes, it's causing great hardship for firms and for clients, but I do see there being genuine opportunity emerging from this based upon using data under the correct controls.
Perfect, thank you. I'm going to take no more than a minute to just reflect on this slide, and then there'll be an opportunity for you to think about any questions that you have for Neil and I. So in the last 2 years, there has been in the UK very little regulatory action. There have been some intentions to fine Marriott and BA, but those fines have yet to come out, and the decision to actually issue those fines is delayed to August. However, across Europe, the most significant number of financial penalties has been around the lawful basis. So I can't emphasize enough the importance of knowing the reason, the purpose and the lawful justification for processing your information, because that will get you in hot water, at which point it is the second thing about the technical measures that then, because of a breach, you are then fined. So please don't think that it will only be technical breaches that will cause a financial penalty. In fact, a lot of the European, and if you have offices outside of the UK that may be in other countries, you may be under that supervisory authority's responsibility. There are a number of ways that you can be fined. So that's just to show that it's not just about breaches of personal data for a fine. So here's your opportunity. We've got 4 minutes before we have to wrap up this session. So for those of you that are on the line now, do you have any specific questions for Neil or I about anything that we have covered? If you do, if you could type them in the message box, that would be fantastic. Obviously, if there are no questions, that's also not a problem. So I'll give it a minute for anyone who wants to type questions in the box for us, and then I'll do a summary of the session. So I can see some of you typing, which is fantastic. Excellent. So we've had some very positive feedback to say. It's been really useful. Fantastic. So I just wanted to, sorry, Neil, was there something quickly you wanted to add?
I was just something I was just going to pick up on there as well, but actually it was just to talk about, just to emphasise very briefly, I think, on the reputational damage as well as the financial implications of things going wrong, in the context of understanding that sometimes when a regulator gets involved, it won't necessarily involve a fine every time. But I would just a really important point that is emerging is the potential for reputational damage, because word will get out, and that can be more lasting than a simple operational or regulatory problem. I just wanted to add that point in, because again, that's another aspect other than the fines that is often grossly overlooked.
Absolutely, well said. I will just briefly sum up a bit of information about the services that we can offer, and then we can wrap this session up. So as Databasix, we have recently launched our GDPR toolbox, which has 6 essential tools. It helps organizations capture data breaches in a log file. It helps you manage subject access requests. We have a ways of working tools that allow you to communicate with your staff whilst working remotely. Neil alluded to the software register. We have that available in the toolbox. And we also have a staff exit checklist that allows you to manage the exit of a staff member, as well as managing your data protection responsibilities. And obviously, Neil, is there something quickly you want to add to anybody about PDA, about the services that you could offer anyone on this webinar?
Thank you very much, Kelly. I'm going to keep it short. I think we're, in terms of all aspects, data protection, cybersecurity, risk, Lexel, client care, we provide consultancy and training all over the UK on these. But I would say that we're quite often the first port of call for just general questions. People contact us sometimes about mergers and acquisitions. There may be questions that people think of after today's session. And of course, we work very closely with you and the team at Databasix, Kelly. So we're able to dovetail into a wonderful expertise of practical real world experience. So if anyone has any questions regarding any aspect of legal practice, compliance, risk in any area, just give us a call, drop us a line, get in touch. Our website's easy to find. We'd be very happy to help.
Perfect. And I think that's, if anyone does want a 15-minute follow-up call, you can indicate in the text box. Just to remind everybody, this webinar has been recorded and will be made available to you in a couple of days once it's been edited, and it will be available on our website. which you can find at dbxuk.com, along with all of the services that we offer from a data protection perspective. Feel free to phone us with any questions that you may have. So what I would like to say is thank you all very much for giving me and Neil 45 minutes of your time. I hope that you have found the webinar to be useful. I wish you every success in the rest of your day today. And do feel free, if you have any questions, to follow up with us afterwards. Thank you. I'm glad it's been informative. I very much appreciate the positive feedback. Have a good day. Thank you, Neil, for co-hosting with me.
Thank you. Thank you.
And goodbye, everybody. And I may see you again online in the future. So take care.